Okay, SURFACE Act 2002. So our common understanding of SURFACE Act is we use the SURFACE Act for takeover of asset, selling it and realizing our money without intervention of court, because this is what we do at the branch level. But the SURFACE, what is the full form? Securitization, asset reconstruction of financial asset, and enforcement of Security Interest Act. So we need to be clear. This act has three distinct parts. One is securitization. Second is reconstruction of financial asset. Third is enforcement of Security Interest Act. What we are familiar is enforcement of security interest. That is what we use. We give notice, we take over the property and sell. But more important is the securitization part. 2-3 questions come from the securitization portion and asset reconstruction, securitization and reconstruction of financial asset. What is reconstruction of financial asset? Say it can be selling for realizing money, or a company can be taken over and run by the secured creditor, or it can be given on lease. All this comes under the reconstruction of financial asset. So what at the start I want you to understand is we are going to discuss securitization separately, reconstruction of financial assets separately, and then lastly enforcement of security interest. This is what we use in the bank and we are mostly familiar. So securitization and reconstruction of financial assets and enforcement of Security Interest Act. This act, essentially what is the importance? Earlier, if you want to sell a property which is secured to us, we have to go to the court, get a decree, and then sell the property and realize our money. It may take 10-15 years sometimes. But now, after the SURFACE, we are directly doing it. We can take over the property and then sell it. SURFACE forms legal framework for the following. So 5 functions have been taken under SURFACE. What are they? First, as I told you, securitization of financial asset. What is securitization? Till the SURFACE Act was passed, there was no law to do securitization legally in India. So the most important point, first point I'm going to tell you. What is securitization? Securitization means you are taking over or you are buying a financial asset from bank or another financial institution. That is, if you have an NPA loan, that is what we are telling financial asset. That is sold by the bank to another institution, or that bank buys that asset, and that financial institution, normally an asset reconstruction company, that company will sell the assets, security, and realize the money. And also this secured assets which are taken over, that is split and is given to investors for investment purpose. So basically securitization means selling of an asset to another company. So normally, asset reconstruction company, they are buying NPAs from the bank. But securitization means in Western countries, the good assets, standard assets also can be sold under securitization. So the securitization is a general term. Securitization means somebody is taking over a loan asset from another company. So it's very common. So one company gives the housing loan, and that housing loan, even if it's a standard asset, it is taken over by another bank. America and all, it is very common. So first understand what is meant by securitization. So SURFACE gives legal framework for securitization in India. 2, reconstruction of financial asset. Reconstruction of financial asset means takeover of an asset with the purpose of selling it or to realize and recover our dues, or it can be reconstruction by way of further running. We can give it to give on lease. All this comes under reconstruction. Recognition of security interest when not in possession of the creditor. That is, some property is mortgaged to us. We have an interest, mortgage interest in that property. That property is in the possession of the borrower. That is, when not in possession of the creditor. Not in the possession of bank. So after giving notice, we can recognize our security interest. It can be hypothecation also. If it's a movable asset, it can be hypothecation also. Power to enforce such security for realization of money due. That is the enforcement of security part. We give notice, we take over the assets, sell and realize our security. Lastly, setting up of central registry, CERSAI, CRSAY. So setting up of a central registry, that also comes under SERFACI. So these 5 functions are incorporated, or 5 functions are taken up under the Security Interest Act. It's an introduction, extends to whole of India. Why we say whole of India? Because earlier Jammu and Kashmir used to be an exception. Came into effect 21/6/2002. It covers banks and financial institutions. Banks means RRBs, cooperative banks, all banks are included now. Housing finance companies notified by central government. So whether housing finance companies are included? Yes, provided special notification by central government is there. Applies retrospectively. Means what? The act is passed in 21/6/2002. But suppose the mortgage was created sometime in 99, 95 or so. Even then, the provisions of SERFACI can be used for a mortgage which was created before 21/6/2002. That is what is meant by this retrospective. Another important point that you must remember, clean loans, unsecured loans are not covered by SERFACI. So you are given a 10 lakh personal loan. You have only a guarantee, no concrete security, no tangible security. In that case, you cannot use SERFACI Act. That means SERFACI Act is not applicable to clean loans. It is applicable only to secured loans. Very, very important. Apply against securities created. So what security we have? It can be hypothecation, it can be mortgage. No court intervention is needed. Straight away, we can give notice to the borrower and then take over, and then we can sell it. Now, please follow this. What is meant by securitization? That is, I've told you the SERFACI. It has got 4 portions. So we are talking about the first portion, securitization. It has nothing to do with what we are doing in the bank. That is enforcement of security. Here we are going to talk about securitization. I already gave you an idea about what is securitization. Securitization means acquisition of financial asset by a securitization or a reconstruction company in the Indian context. That is, an asset reconstruction company or a financial asset is taken over from the bank by an asset reconstruction company, or the bank sells the financial asset to a securitization company. That is called securitization. Once the asset reconstruction company purchases that loan, so the loan is purchased, he becomes along with the security, along with the mortgage property. So whatever rights the bank had, that is handed over to the securitization company. A sale of asset without recourse to the bank or a file means we have sold the NPA to asset reconstruction company. Asset reconstruction company is supposed to sell, realize the security and recover the money. Suppose there is a shortage, can the reconstruction company come back to bank and say, you have to give the balance because the debt was 10 lakhs, I could recover only 8 lakhs, so 2 lakhs you give. That is not there. So recourse to bank is not available. Who is the regulatory authority for securitization? RBI. Important point. Acquire asset by raising funds from QIB, qualified institutional buyers. So you see, an asset reconstruction company has to purchase an NPA from the bank, from where the money will come. Asset reconstruction company has got capital, but that capital cannot be used for buying these securities, buying this financial asset. It has to raise money from the market. Who will give the money? There are institutions called qualified institutional buyers. They buy security receipts issued by asset reconstruction company. So that money comes to the asset reconstruction company. With that money, it pays the bank or it purchases financial assets from the bank. So that is why acquire assets by raising funds from QIB, What is a QIB? Please remember, you keep it in mind. We will have further discussion on that. Now, securitization or reconstruction company, how it is formed. So we are starting at the beginning. A securitization company is going to start business. The company is registered under Companies Act 1956 or 2003. Registration with RBI. So, important point. Securitization companies are registered with whom? Question. RBI. Why this is important? Just now we talked about qualified institutional buyers. QIBs are registered with SEBI. Both come in the securitization. So please take note. QIBs are registered with SEBI. Securitization companies are registered with RBI. Net owned funds not less than 100 crore. 100 crore, you must remember. What is the minimum net owned funds to be owned by a reconstruction company? RBI can cancel the license, just like bank. The license given to reconstruction company can be cancelled. Who is the appellate authority? The construction company can file an appeal to the government. Within how many days? 30 days from the date RBI issues cancellation. Okay, so 30 days, Government of India is the appellate authority. Two points we are getting. Securitization or reconstruction company license. License, we have told, can be cancelled. When it is cancelled, ceases to carry on securitization or reconstruction business. That is, they are not doing that business. Cease to receive or hold investment from QIBs. That is, the asset reconstruction company is formed with 100 crore. But if it wants to take over asset from a bank, it needs money. That money should come from where? From QIBs. If money is not coming from QIB, license can get cancelled. Fails to comply with guidelines of RBI. Changes in management registered office without RBI approval. That is, if there is a management, there is a change, RBI approval is needed. If it is done without RBI approval, the license can be cancelled. Now, securitization process. A company is formed. So how the company goes about? Now it wants to start business. It approaches a bank or the bank approaches the asset reconstruction company. So they say, we want to sell, say, 100 crores NPA to you. If the asset reconstruction company agrees, it has to first come out with an offer document. What does offer document contains? We have found that in the earlier we have found that if a company wants to raise funds from the market, public issue, a prospectus should be issued. Same thing. Before takeover, the asset reconstruction company has to raise funds from the QIBs. So a document is necessary to tell what are the assets being taken over, this housing loan, what are the securities, how much security is available, formulate separate scheme for acquisition of financial asset. That means, let's imagine Canara Bank is selling 100 crores to a securitization company. Okay, fine. That deal is over. Say after 6 months or so, Canara Bank says, we want to sell another 50 crores. First was housing loan. Now these are mortgage loans, 50 crores. So the same asset construction company, if it is taken over, these two loans cannot be combined. The first 100 crore, it has to formulate a separate scheme. For the other 50 crores, it has to formulate a separate scheme. Understood? It cannot be combined. They need to have two separate schemes so that later on it is clear what are these 50 loans, who has taken over, to whom. Create separate trust for each scheme and keep records separately. That means it has to create a separate trust to deal with the first 100 crores. Then another trust to deal with the next 50 crores. The asset construction company itself can act as the trust. Now, consideration. You see, the Canara Bank has handed over 100 crores of housing loan to asset reconstruction company, NTPC. Canara Bank is to be paid. Do they pay all the money, 100 crores? No. Sometimes maybe some money is paid. Otherwise, this asset reconstruction company issues debenture in favor. Say 100 crores, let us say it pays 10 crores in cash, 90 crores, it will be issued debenture. So Canara Bank will hold the debenture issued by asset construction company and sell that 100 crores housing loan to asset reconstruction company. there will be an agreement. What are the terms and conditions? This asset, this debenture issued, it should have a period. Say within 3 years, we will pay the money and take back the debenture. Anyway, the maximum period allowed for the debenture is 6 years. That is, asset reconstruction company has to recover all the money and redeem or repay the bank the cost of the NPA taken over within 6 years. Now, agreement. Who is the originator? So this term, when you see the originator, you have to understand originally who gave the loan. Originally who gave the loan is the bank. Canara Bank gave the loan. So originator is the person who gave the loan. And for the security, surface purpose, the person who has taken the loan, the borrower is called obliger. You have to remember, don't get confused by the term obliger. Obliger means either the borrower or the guarantor, meaning who has the obligation to pay that loan. That is why he is called obliger. So you have to remember who is an originator. Security receipts issued in favor of investors. You should know what is security receipts. You see, 100 crores NPA has been taken over by securitization company. That is what securitization. Now, this 100 crores NPA is now in the hands of securitization company. They give debenture to the bank as a payment. Now, this securitization company wants money to pay to Canara Bank, or first it has issued debentures, then the debentures has to be taken back and paid. So from where it gets money? QIBs. It will give offer document as QIBs who are interested. And who are QIBs? Qualified institutional buyers. That is institutions which are registered with SEBI for the purpose of participating in securitization process. So this 100 crores housing loan taken over by the securitization company. So it has formed a scheme, it has formed a trust. It will split this loan into small components and sell it to the QIBs. Say 100 crores. It will split into 1 crore, 1 crore, 1 crore, 100. Maybe 25 crore, one QIB will give, and it will give 25 crores. Say another QIB may invest 30 crores and take. So what they will be given? Security receipts. So security receipt is given to the QIBs. They will be holding it. Say all QIBs together, they will be holding 100 crores worth of security receipt. Now, this asset reconstruction company will sell the securities. They are supposed to sell within 5 years, realize the money, and then give the money back to QIBs along with interest, and will take back the security receipts. And the money collected from the QIB security receipts, money has come into the securitization company. That money will be utilized to pay the bank, and they will take back the debentures. So within 5 years, the securitization company should sell all the property and should realize, and within 6 years, the banks, the QIBs, everybody should be settled. This is the overall picture of securitization process. So acquisition of financial assets, undivided interest therein. That is undivided interest. The 100 crores NPA is taken over. Maybe 150 crores or 200 crores of worth property is there as security. So various QIBs are giving money to securitization company. Say one company has given 25 crores, another has given 30 crores. So that company is asking, you have taken 24 crores from us. Where is our security? That securitization company cannot show. That is why this undivided interest. All that securitization company can say is total value of security is 100 crore. So you will get, if you have invested 25 crores, your share is 1/4. Undivided share. Which 1/4? You do not know. You cannot say. Out of 100 crore, 1/4 is yours. 30% belongs to another company. It's like when you buy an apartment, that land will be there. That land around the apartment belongs to all. You are an apartment owner. You say, you tell me which is my land. There is no land. No promoter can say. Promoter will say, you have an undivided interest. If 100 flats are there, the land around the apartment belongs to 100 flat owners. 1 by 100 is his share holding. But which is this 100? You cannot say. They are not going to mark and give you. Similarly, the securitization company is holding 100 crores and various QIBs have given money to acquire that. So QIBs, some would have contributed 30%, another would have contributed 50%. So all the securitization company can say is 50% is yours. So that is the significance of undivided interest. So that you have to remember. The QIBs have only undivided interest in the assets taken over. Issue security receipts in favor of investors. Investors are beneficiaries. The stake is undivided interest in the financial asset. This is what we are told. Investors means QIBs. All rights of lending banks thereafter vest with the company. All rights of the bank is taken over by the asset reconstruction company. Liabilities of commitment to be discharged by bank is not passed on to the company. Very, very important point. Only asset is taken over. If there is a liability involved for the bank, then asset reconstruction company is not taking over the liability relating. Asset reconstruction company will take over only asset part of it. All documents in which the bank is a party fully in favor of the company. That is, the borrower has executed documents in favor of the bank. All once it is sold, the asset reconstruction company can enforce those documents as if it is given in favor of asset reconstruction company. Any suit can be continued by the company. That is, the bank has filed a suit already against the borrower. It can still sell. And that suit will be taken over by the asset reconstruction company. Company can request for transfer of case to one DRT if multiple banks are involved. That is, same maybe consortium account when asset reconstruction company takes over. In that case, it can consolidate and take the case to one DRT. Now, very, very important point, whether notice to the obliger is necessary. What does that mean? Obliger means borrower. Canara Bank has given housing loan. That housing loan now has been sold to asset reconstruction company. So the question we are answering here is whether asset reconstruction company should give a notice to the borrower, original borrower. SARFAESI says not mandatory. In law, it is not required. But if you want, you can give a notice to the borrower. The bank can give a notice also that we have already sold. Now follow-up will be done by the asset reconstruction company and not the bank. So remember, obliger is equal to borrower. Now we have told the notice is not necessary to the borrower. Suppose the borrower is a company and we have given a notice to the borrower. It is not necessary. But to be on safer side, bank has given a notice to the borrower that your account is being sold to asset reconstruction company. So if that is done, if it is a borrower is a corporate or a company registered under Companies Act, a copy of the notice has to be given to ROC, Registrar of Companies. These questions have been asked. So these are all very, very important points, whether notice is to be given or not. Notice need not be given. If at all notice is given, if it's a corporate borrower, then it is incumbent on the part or it is mandatory on the part of the bank to give a notice to ROC also. Raise funds by issuing security receipts to QIBs. We have already discussed. Security receipts are transferable. That is, one QIB gave money and got the security receipts. Afterwards, that QIB can sell the receipts to other QIBs. Registration required only when it is transferred to another person or if the SR is creating, declaring, assigning, limiting, or extinguishing any right, title, or interest in any immovable property. So normal course, when a security receipt is transferred to another person, no registration is required. So security registration, transfer registration is required? No. Only if it involves transfer, that security receipt transfer, it also is attached transfer of an immovable property. Naturally, as per the Transfer of Property Act, the transfer of immovable property needs to be registered.
If you like our content, do like, share and subscribe.